Ashley Meyer-Dunham.
And I'm April DeLuca.
And we're with Magic City Law. We are a family law boutique firm located in Birmingham, Alabama. And today we're going to be discussing the divorce process.
So divorces generally fall in two different categories, contested and uncontested. Today we're just going to give you some very general information on the divorce process for a contested divorce. Contested really just means that you and your spouse can't decide on how to split your assets or custody of your children and you need the court's help.
The very first step that you actually need to take if you're thinking about getting a divorce is you need to call and make a consultation with a divorce attorney. You could call a random threshold attorney, but I always suggest that you make sure that you give a divorce attorney or a family law attorney or a matrimonial law attorney a phone call. At our firm, we do charge for our consultations. We charge $150, and that is with an hour with both of us. So you're not just going to be talking to one attorney, you'll be talking to both of us. You'll be getting our case plan, our action plan, if you will. You'll get to talk to us and get legal advice from us. It's one of those situations where you come in, you tell us your story, we listen, and we listen to what's been going on, but we also give you some sort of vision for the future.
The second step in the process would then be to hire the attorney. You can hire directly as a result of the consultation while you're still in office. We always prefer that. You're also free to go and talk to other attorneys if you'd like. But with our firm, if you decide to hire us within 48 hours of that consultation, we'll apply that fee you paid toward your retainer. Your retainer is going to depend on a variety of factors, which you'll learn about at the consultation.
Now, we'll later make a video that has to do with what a divorce actually costs. We can't ever estimate that completely, but we do give you a decent estimate on what it's going to cost to get going and what it's going to cost to possibly finish your case. But then again, you have to remember that each case varies. That's the most cliche lawyer thing I could ever say, but every case does vary. So step 3 of the divorce process is filing the complaint. After we get paid and we have our consultation, we use the information that you gave to us to draft something with boilerplate language most of the time, depending on the situation, and we will file that with the court, which basically states exactly what you want from the court, what you want them to grant you.
You can also, at the same time as you're filing your initial complaint, file any emergency motions that need to be filed. These would generally cover situations where your children are in danger, or your spouse is abusing drugs, or there are financial assets that are being depleted, things like that that you need immediate help from the court to address. And these motions can be filed at the same time the complaint is filed and served on your spouse at the same exact time. Step 4 in the process is motion, motion, motion. This is the time when you're going to file all sorts of motions for all sorts of situations, but they're not necessarily emergencies, so they come a little bit later in the process, generally after your spouse has been served with that initial complaint we just talked about. The most common type of motion is called a motion for pendente light relief, which really just means temporary relief pending litigation. This is where someone can ask for temporary possession of the home, temporary custody of the children, somebody can be ordered to pay temporary child support, temporary alimony, you can get temporary restraining orders, all sorts of things can happen during these motions.
Now, there are other types of motions that can come around, because here's the thing, is a lot of court cases, they usually last about, let's just say, depending on the county, from a year to, as we said earlier, 3 years. These things can last a very long time. So during that time, there are things that come up that you need the court to address. It doesn't necessarily mean you're going to get a full day of trial, but you may end up in a full day of trial. I mean, we had a few where we ended up stuck in court for 9-10 hours on something like an emergency motion. But there are all types of motions that your attorneys can file, like a motion to compel discovery.
Or you could do a motion for drug testing or substance abuse testing if you think your spouse is doing that.
Or you could file that on the opposing attorney. Maybe a motion for drug testing on the opposing attorney.
We don't ever do that.
Just kidding. You can also do a motion to compel visitation. Say that you're not getting visitation. There may be a situation where the children are being held from you and you really, really need to see them.
Or motion for psychological evaluation of your spouse if you think that that's an issue.
Or a motion for court guidance.
Motion for co-parent counseling.
A motion to address former motions.
And now I'm going to make a motion that we move on.
Okay. Step 5 is going to be negotiation, which of course the entire time we're trying to negotiate for you. We don't just think, okay, let's try negotiating later on. A lot of times the first thing that we do in our firm is we'll go ahead and contact the opposing counsel or opposing party and say, hey, let's negotiate and try to get this to work out. If you don't respond in a few days, then maybe we need to seek the court's help. So a lot of times the best thing to do is to negotiate along the way.
And be prepared for negotiations taking a long time. You may come into a negotiation with your attorney thinking you have all the issues nailed down to there are 3 things that you need. And your attorney goes and talks to the opposing counsel and she comes back with a list of 20 things that they want to discuss. So be prepared. Negotiation is not easy, but it can be very rewarding and can really help get a settlement that you and your spouse are going to be happy with, and it'll be something that can be better than what you would get from the court.
We always tell our clients that we work with sugar first. We try sugar or honey, and then if that doesn't work, then we go to trial.
So step 6 is a process called discovery. And discovery can also be very long and very expensive, but what discovery is our way of determining what your spouse's case is going to be. We are asking questions in the form of interrogatories. We're asking them to produce documents, and sometimes we ask for requests for admissions. Also, depositions can be scheduled as a part of the discovery process. Again, this is why it gets very expensive, but it's a necessary evil if you think your case is going to go to trial. And even if you don't think it may go to trial, you think it can settle, discovery is still really important because we need to know your spouse's tax information. We need to know if he or she is hiding assets, if they own a business, or are a partner in a business. We need to know the value of their interest in that because it could be considered a part of your marital estate. So all of these things are very important, and discovery is the best way to find it out because they are required to answer these things under oath.
Now you have to realize that just because it's under oath doesn't mean that your spouse is going to tell the truth. So step 7 is trial prep. We like to be prepared. I don't know many attorneys who would not want to be prepared. So when it comes to a situation where we think, oh yeah, we're going to trial, may it be that the opposing party just won't settle, or the opposing attorney is very difficult to work with, and we think, okay, maybe we'll be able to settle when we get there, but until then we need to make sure that we are most definitely absolutely prepared. So we have an appointment where somebody comes in and we'll do trial prep at that point. A lot of times we'll have already gotten all of the exhibits together, which we can discuss exhibits on another one of these. But we'll have the exhibits here ready for you to look at, and we'll go over your questions to see how you're going to do on the stand. A lot of people get really, really nervous about the actual trial and what's going to happen because they've seen, I don't know, a bazillion John Grisham movies, or they've watched Suits, or they've watched Drop Dead Diva, and they think that they know that court is going to be terrifying, when in reality things are a little bit mundane, if you will.
And that brings us to our final step. Step 8 is trial. Hopefully we won't get here. Hopefully your case will settle before trial. But if it doesn't, trial is really not as bad as you think. Trial is a lot of hurry up and wait. You're set at 9 o'clock here in our county. You show up at 8:30, we talk for a few minutes, and then we go in for what's called the docket call. And depending on who you're in front of, there are probably going to be about 20 or so other cases on that set for trial the same day you are. So we all go in, judge does docket call, which is kind of like calling attendance when you were in school. We all say we're here. The judge will generally call the attorneys up to the front and want to know what's going on. She'll want to know if we need to talk, if we're close to settling, or if we think we're actually going to need a trial. The judge is secretly hoping we're not going to really need a trial, just like we are, but a lot of times we really do need a trial. She'll ask how many witnesses each side has, how long we think it's going to take, and then she'll tell us, okay, come back at like 10 or 11 and we'll get started. And so she'll hear some of the other small motion hearings before she'll hear our trial. She may go take a break before she has to sit through hours of endless testimony. But nevertheless, we'll get started at the time she says for us to come back and get started. So there's a lot of hurry up and wait. You're going to be sitting there, you're going to be nervous, you're ready to get on the stand and get your testimony over with, and then you'll be told, Judge wants to see the attorneys in chambers. So the attorneys get up and go talk to Judge, and you're left sitting there. Bring a book, bring a snack, bring a jacket, ladies. The courtroom can get very, very cold. And just remember that the entire time we're there, we are advocating for you, and we're trying to get your case to a resolution that will be good for you and for your children, especially if you have kids.
Just remember that trial is actually very, very taxing on everyone involved. It's taxing on the attorneys because, number one, we have to be extremely on the entire day. So we have to make sure that we're paying attention to the other side, to our side, to the judge's facial reactions, to our client's emotional needs. And at the same time, we're also having to, a lot of times, go without food for many, many, many hours. And I don't know about other lawyers, but we get a little hungry sometimes. So also bring a snack for us. Just kidding. That's it. That's basically the entire divorce process in a nutshell. But make sure you realize that this video is probably a lot shorter than what the actual divorce process is going to be.
Stay tuned for more future videos from us on different topics in family law. Be sure to check out our website, our Facebook page, and our Instagram account, Magic City Law.
Thanks, guys.